Very good morning to all the faculty members, students, and our honored guest today. I heartily welcome all of you to this enriching webinar on the topic negotiating contracts. To help you all gain knowledge on the same, we have amongst us an expert, Ms. AKANKSHA Sharma. She is a senior legal counsel at Nestle India Limited. Ms. Akanksha specializes in commercial laws, which include contracts, competition, and mergers and acquisitions. Prior to Nestle, she was associated with top law firms, S&R Associates, and P&A law offices, which she supported multiple high-value cross-border deals and transactions. As a versatile professional, she has gained exposure to all the elements of commercial transactions and developed a very good understanding in many areas of law, such as labor law, employment law, environmental law, alternate dispute resolution, property law, and many more. She is a qualified advocate registered with the Bar Council of India and is currently practicing in New Delhi. Without taking any further time, ma'am, I would request you to please take this session forward and share your knowledge and valuable experiences with our students on this topic. Over to you, ma'am.
Thank you, Garima. Good morning, everybody, and thank you for having me here today. I would begin by presenting my screen with a brief presentation to take this session forward. So let's begin by understanding what is a contract. Well, the basic definition, I'm sure all of you are aware of, we learn it in law school, which is basically an agreement which is enforceable by law. Now, that is the simple definition which we learn, where we learn the basic elements, an offer, an acceptance, and a consideration. I'll take it through a real world situation. That is really not how it works, because when you have an offer, you will always have a counter offer, sometimes multiple counter offers. When there is an acceptance, again, it could be a conditional acceptance. When there is a payout or a consideration, it could be in tranches, stemming over years. And that's when a contract kicks in. It's not as simple as today an offer is made, you accept it, and you make certain payment for it. Because in business, our relationships are always long term. We have to keep that in mind when we draft a contract. What are the interests of the party? And there's a lot of back and forth that goes around it, which is what we call a negotiation. Always remember that a negotiation has to be a win-win situation. You cannot walk away from it being the sole winner, because there are two parties involved. And when you have to ensure business continuity, you have to make sure that both parties are equally happy. So that is when we discuss these elements of contract in much more details and how they really play out in the real world situation. Now, when we negotiate a contract, what do we have to keep in mind? So there is something which is very simple, which is something you can quantify, which is the consideration amount. So you know that the contract is worth 1 lakh rupees, or it is billable worth 2 lakh rupees, or there is certain amount of raw material which is involved. This is the easy part, because this is something you know, a number that you can keep in mind. But when you go into a detail of a contract, that's really not how it works, because you have to see what is the business need. Say my contract value is worth 1 lakh, but there is only one supplier in the market, and he's the only person who has that much raw material available to me. And he says, no, I will not do this work for 1 lakh. I'll do it for 20 lakhs. And this is a business need. You really need this material. You really need this work to go. So what would you do in that situation? How would you meet him halfway? And then again, what is the halfway? So the business need kicks in. Is it really urgent? Do you look for other suppliers? Do you look for other vendors? Is there something else that you can do about it? Can you stagger your payments? Can you make some upfront payments? What other ways can you negotiate? Can you break this into various multiple vendors of yours? So this is something which you have to keep in mind. Then the next is, who's the party who's involved? When you work with someone for the first time, even in your real life, you are a little skeptical, maybe a little apprehensive. You don't know how things would go. But say you're working with a long-time friend of yours, you have a lot of more trust that is already built in. you can let go of more things over there, or you can negotiate, or you know how your friend works, right? So you would be more comfortable with his ways of working. You would know that this is something he will do, this is something he would not do, and maybe work around basis that. So your business need also evolves, but you also have to maintain your partnerships as you go along the way. So one thing that you have to keep in mind when you negotiate a contract is that you don't have to go headfirst into it thinking it's my way or highway, because once you take that approach, which I have seen certain times in my experience, people do start with that aspect that, I have said it, so this is right, or this is what is needed, so this is the way it should go. This often lands us into trouble, because that's not how a business works. Always collaborative effort. You have to take it forward together. But what is important is that you have to ensure that whatever are your interests are deeply protected at all costs. So when you work for a party for the first time, probably you may go a little heavy, not as easy on them. You would be a little skeptical. Maybe your clauses are more tighter in nature, which is natural. As you go along the way, you would relax it. So these scenarios keep changing. It's not something which is set in stone, or it's not something which is fixed or you have to abide by it. Each contract is unique in nature. The expected nature of disputes. Now you have to always think ahead. As a lawyer, your job is not just to see what is happening today. You have to draw from your past, but also see the future as well. So when you enter into a contract, you have to see what is the need of this contract. Supposing this contract is opened or there's some dispute 10 or 15 years down the line, how would it play out? Because that is how long the contracts are. One thing I would like to say is, if you have drafted it well and your contract is never disputed, or it never, let's say, is adjudicated by Supreme Court of India, you've done a good job. So your work not coming into limelight is probably the best in these kind of situations. Just something to, keep in mind. The other thing is the time period. So a lot of people don't keep this in mind when they're negotiating a contract. Sometimes a business deal is, let's say, something worth 2 months of deliverables versus 20 years. So this is something to keep in mind, that is it just something which I'm going to take as a supply versus a service, because a service involves a human element. And that means that a lot more things can go wrong when human nature is involved versus a good supply. Is it short term versus is it long term? Time periods make a lot of difference in the way you negotiate. You have to keep it in mind that, is this an instant business need which I can close in 2 weeks and simple supply arrangements, or versus is it something long drawn, setting up a whole unit in itself, a manufacturing plant, something which is heavy duty, combination of both human versus artificial elements. All these things have to be kept in mind when you negotiate even the simplest of agreements. Always remember that a simple agreement can turn really, really complicated really, really fast, depending on what is at stake. The quantifiable is one aspect of it, but reputational is a whole other ball game. So for the clients that I have worked in the past, all having really high repute, the company I represent today, which is a market leader in itself, so we have to keep in mind that, these are some aspects that are very, very close to any big company or even a small company, because reputation is very, very important in the eyes of people. Things can go south very fast. So always, while representing, whether you're representing a client or a company or yourself, always remember that your value is very, very big, and it has to be kept in mind when you negotiate something, which is something which cannot be quantified today. So what do we look at when we draft a contract? A common mistake that people make is that they jump straight into the main portion, let's call it that, like the one that stands out to everybody, which is very apparent. And then that's where they go, and then that's where they try to make all the changes. Some people go the template route, which they think that, oh, this is a standard running in the market. But unfortunately, that is not a case, because every contract is very unique and every word matters. So if your first clause is saying something, which is your scope, versus your second clause is saying something else altogether, which is a representation, and you just go and look at your representation because that is the one that's most common, or that is the one we go to first, the mistake that we make is that a contract is read as a whole. It's not ever read piecemeal. So this creates an inconsistency, which of course is a way to call it unfortunate or a badly drafted agreement. We have to make sure that whatever is written should tie in with the rest and not to rush through any agreement of any nature. So every word in a contract does matter. Some of the key clauses that, yes, that you should look out for is your representation and warranty. A representation is a simple fact. Warranty is something which you can warrant going forward in the future as well. Representations and warranties are really important, especially in heavy duty contracts like share purchase agreements, which have long term consequences because companies are exchanging hands. But even in your small service agreements, they're equally important and equally relevant. A lot of enforceability comes from these clauses. The next is deliverables and KPIs. From a business perspective, a business is looking at what is it delivering or what is getting delivered to it, and what has to be kept in mind. Certain benchmarks or a certain parameter or standard is very important to any company when it is at work. So this is something which often goes amiss when you're looking at a contract. Always remember that a commercial contract has the word commercial in it. So you have to apply your commercial knowledge or your commercial sense to a contract. This is very important. Just blindly putting in legal clauses without any application of mind is not in the best interest of your client or your business. This is because it has deep relevance for them. So when you look at disputes outside in the world, you always listen to the bigger disputes, which are publicly made available to you, like a dispute which is worth 3,000 crores or 2,000 crores. But in a day-to-day business, we see a lot of issues that can arise, which are not of as big a nature maybe, but have huge consequences on business continuity. So these agreements often kick in, but maybe you can say at a small scale, and these are also resolved very amicably. So they don't always have to come up in the media light. So that is where a good contract kicks in. If you set down your deliverables and your KPIs properly in a comprehensive manner, then things do roll out smoothly. So contracts should not be taken lightly because that is where you rely on when it comes to your day-to-day actions or activities. Um, then termination clauses. So how do you get out of a contract? It's very easy to get in a contract, simple signature, few KPIs here and there. But as you would have seen in the COVID situation, there have been so many disruptions in the market. There has been so-called enforcement of force majeure all over the place. But how do you terminate your agreement? How do you make it amicable? Or if there's a dispute, do you have the relevant clauses in place which can help you move out of the agreement? Or if you're tying in someone into the agreement, is your termination well bound so that you can make sure that they are not using it incorrectly? It counts both ways. So this is something which you need to keep in mind when you draft. And now the most commonly debated clause, which is our indemnity provision. So in an indemnity provision, which often people miss out on because they think a standard indemnity can hold good, that ABC is indemnifying XYZ for all losses. Each word in an indemnity provision really matters. It is placed there for a reason. So to give you an example, consequential losses in India are not enforceable as a concept, but for a business, a consequence can be huge. So I cannot directly enforce something in India. How would I save my business interests? To delve into this a little deeper, one way to look at a loss is a direct and actual loss, which is enforceable. So a product has not reached its shipment point. Product was worth 100 rupees, and that is the extent to which you can make a claim. This is very simple, easy maths. But now you have made a further commitment to make sure that the product reached the market, and there the product's price is 120 rupees. Further, that product was going to go somewhere else. So now there's a consumer commitment involved. These are all consequences of an action. In India, we cannot really enforce this provision. So how do we take care of such a business loss? I will leave this question open for you to think about it because there's still much debate in this area. But coming back to our indemnity provision and how it works. So in indemnity, the tighter we make it, the better it is. The more comprehensive you make it, the better it is. Not something to leave around loosely. So one thing that you should see from the clauses to watch for is not to rely on templates, because one shoe doesn't fit all in contracts. And now coming to what really goes unnoticed. So there are small things, and we are all human, and often we are rushing through things, even contracts. So there are few things which, go amiss. One is incomplete schedules or inconsistent schedules. A lot of time, how lawyers see it is, I have drafted the agreement and then the rest of the annexures are all commercial in nature, or these are all prices and I should not take a look at it. Yes, agreed that we are not people from finance and we may not know the implication of each number set out, but these have a huge impact. So every schedule has to be properly tied into your agreement. A lot of times this is missed because people don't take it lightly, or people think this is something in the background, but they forget. Now I will relate this to your boilerplate clauses. By boilerplate clauses, I mean the so-called miscellaneous clauses that you have in an agreement, where you say that all documents which are connected with this, including all schedules, form a part and parcel of this agreement. Usually I have noticed that lawyers don't look into the boilerplates or miscellaneous clauses. They take it as a standard coming from all agreements, and they don't really get into the meaning of these provisions. But what really happens is, if you look deeply into this so-called miscellaneous clause, which is not given its importance, you have made your schedules part and parcel of your main agreement. And you have not gone through the schedule. So you don't really know what it really means. Maybe it looked too commercial to the eye, or maybe you thought that it's not relevant. I have just marked it as connected to this. It's some KPI and it will get fulfilled when it has to get fulfilled. And now you realize when you're interpreting this contract that the schedule said X and your contract is saying Y. That means somewhere in your contract you said the delivery would be in 10 days, but when your commercial team looked into the schedule, they changed it to 15 days because they thought, yes, in business practice, it can be up and down by a few days and we can give this leeway. But here, because of maybe the lack of communication, this gap was not bridged. So what would get enforced? How would you look at this agreement? Would you look at it 10 days or 15 days? So this is something to keep in mind, because this is something that often goes unnoticed. Don't think that in a contract the rule is only a legal provision. As lawyers, yes, it is our duty to safeguard our interest, the company or the businesses or the client's interest completely, but not just from a legal standpoint, from a commercial standpoint as well, because the business that is coming to you for help is looking at you to protect its interests, not just legally but commercially, not just today but also in the long run. So a good lawyer is one who keeps that in mind and bridges that gap and make sure that all of it, the detailing in a contract is comprehensive to the business. Now we come to what is negotiated and what made it to the paper. So this is also somewhere we usually miss out on. Negotiations are huge and heavy. They can last months, sometimes even years, depending on the nature of the transaction. Often we are negotiating and we are saying something that, yes, this is possible, this is feasible, but when it comes down to penning it on paper, so it doesn't really make it fully as to what was discussed between parties. Now, once your contract is signed, any negotiation that you had, whether it was verbal or whether it was in writing, it doesn't have any binding value left because the contract supersedes all that past discussion that you had. What really happens is, if you are taking up a negotiation standalone, commercials or maybe another team, let's say there's a technology team involved, there's a business team involved, and everyone is just going on their own and there's no collaboration that is involved, then what makes it to paper can become really complicated. And then it becomes that, but this is what we thought was going to happen, but this is not penned over here. So often this happens that a lot of things we assume that, yes, this is how the way it works. So why is there a need to put it on? This is a very big mistake, because when disputes happen, what is written on paper is what matters. So always ensure that what is negotiated and whatever is relevant is properly penned down. Anything which is spoken, and not put on paper and not signed will not really have any value. So it is, while it is good to trust the practices, it's always best to capture them. Now, cross-referencing. So one of the reasons I put it out here is because all of you are young lawyers, you're just starting out. So when you will start out, one of the most mundane tasks that you will find is cross-referencing. And I often hear this complaint from junior lawyers that this is so boring. Why am I mapping numbers against numbers, or even page numbering? These all look like mundane tasks, but actually they have really, really huge consequences if they go wrong. So when you are mapping your agreement clauses one to another, or penning your liability, that in case of, let's say, confidentiality clause number 1, um, the penalty will be 100 times, versus missing out on a deliverable penalty would be 50 times. And now you have cross-referenced all of this, 1 against 2 and 2 against 4. And while signing the draft, you don't look through it completely. So that changes the whole scheme of things. It does, again, it doesn't really matter what you negotiated or what you thought was equal to what. Now this sort of an aspect which you think, oh, this is mundane, or this has to be done again and again, which it is true, we have to do it again and again, and there's a reason for that, because it is relevant. It comes out to be a huge consequence. So one of the things that you should keep in mind always is, no task while doing your contract is small. There is no such thing as this is too mundane versus this is too important. And never get fixated on, just because I got the best indemnity provision, which you will realize as through your course of the career is very important, that the rest is not important. That is incorrect way to go about your contract, because remember, it is never read standalone. Your contract is never read standalone. It is always read holistically. So a small thing like a cross reference can go a long way when it comes to mapping your consequences. So before I close on this, one of the things that I have noticed during negotiating is the business interest, which often lawyers leave behind while going into this ego battle of who's right. Now, as in my course of career, I have moved from a law firm to a company. So there has been a significant transition, and I've been on both sides of the table, and I'm quite privileged that I have seen both sides of the story. So what really happens is, a business is always looking at collaborative effort, and it is looking at people coming together and work happening and deliverables being taken up in a manner, consumers being satisfied. That is its end goal, that it should all run smoothly. And reputation is a matter of big consequence for any business. Versus when you are doing something like a transaction which is a share purchase, or a heavy duty transaction where the businesses are exchanging hands, there the consideration and stakes are higher. The volume is not as high, but the consideration, quantity, and overall business interest, because it's a sale of sorts, is higher. So these are both looked at differently. When we look at a collaborative effort, or when we look at a transaction where a business is involved and its end goal is to satisfy consumer, the way to work is to keep in mind that it is not an ego battle, that you got one provision in the contract to your satisfaction and that is the best way to go about it. That is not, because you are partners with people you're working with, your vendors, your suppliers, your consumers. They all come together in that ecosystem to make your business happen. So you have to somewhere take a neutral ground and protect your business interests as well. So it is very, very important to put your foot down when it is required, but it is not a good idea as a lawyer to go into that battle of something which is insignificant and consumes time of your business. Because in my experience, when you're working with a business, everything is actioned out instantly. So if you don't get a contract signed today, your shipment is not going to leave tomorrow and the customer is not going to have the product in day 3. That is how fast it moves. So you have to know what to keep and what to let go, and this happens as you go over course of your business and to realize what is important to business, what should you keep in mind most. So you have some priorities which you should demarcate at the beginning, versus some things that yes, this is a long-term business partner for me, and yes, they have delivered XYZ and this is how they work, so I should be a little flexible to that extent. And then there are some no-goes, which is your ethics and values for your company or your business or your client. You have to keep those ethics in mind. Ethics are the most important when you draft a contract, because that is the fundamental or common base for all of your agreements. The next is coming from the other side. Now, how do we look at a share purchase where there is heavy duty? Again, yes, to an extent you have to let go, because this is also important. You have to make sure that somewhere the contract is meeting interests of both parties. We don't look at contracts the way we look at negotiations. But in a share purchase, of course, it's not a collaborative effort, because once the business has been bought over, it is moved to the other side, right? Or a sale is happening and you're on the sell side. So you have to make sure that you do get the best cost for the business, and you have that business that you built over so many years of time. So the interests change. So one thing to keep in mind is, every time you're doing a contract, what is that nature of the contract? Is it a service agreement? Is it a sale purchase agreement? Is it a slump sale agreement? Is there a transaction of assets? You will don a different hat for each contract that you're doing. And this is something which is very, very important and goes amiss, because this is where our templates fail us, because you can't really blindly take one and copy to the other. You could be on one end of the pole in one transaction and completely opposite in the next. So you're selling at sometimes and you're buying at the other. So that changes your interest completely. This is something you have to keep in mind when you draft or you negotiate anything and everything. A common mistake that we make is that we take one and then we apply it to the other, where we have changed sides, and this often goes against us. So whenever you start with a negotiation, the best thing that to do is to take a step back, clear your head and see what is the priority, who are you representing, whoever you're representing, what do they want, what should be the final outcome, and how do you get to that outcome really, really fast, but keeping in mind that there are no mistakes and no loose ends, because loose ends always cost a lot. So that is something to keep in mind when you negotiate a contract. The best outcome is obviously one where everyone is happy. That is not always the case, of course, but the ideal outcome for you is where your company or your client stands fully protected, and you are satisfied with the overall outcome, and you know that 15, 20, 30 years down the line, if the contract is open, it still holds good value. So that is all from my side. Thank you.
Ma'am, can you please stop the screen share so that we can start with the Q&A? Thank you. Thank you so much, ma'am, for sharing such in-depth and clear and very simple in a very simple ways. And our students have shared a lot of questions based on this. Shall we start with the Q&A, ma'am?
Sure.
So the first question is, how has pandemic affected the commercial contracts in India, especially in the light of force majeure? Can negotiations in any form help?
Okay, that's a good question. So pandemic is, of course, a recent phenomena, and no business could have predicted it in advance, or no person could have predicted it in advance. So what I have seen in my personal experience is we had to transition very fast from the general nature of contracts to taking everything virtually. The force majeure clauses, well, to be honest, we had to look at it from good business sense and see how to work amicably in the ecosystem that we had. Yes, they did come into play significantly, but overall we have to, since we have to maintain the integrity of the business, that was kept in mind, and it was taken up more amicably. You should remember that a force majeure is a clause which comes into place in disruptive situation, not in a situation where things happen at a fault of a party. It was more of natural causes.
Right.
So keeping that in mind, we did build into the future contracts such kind of situations. Hopefully they will never arise again. But this is a good learning to keep in mind the relevance of these. Like I said, some things that go unnoticed. So force majeure was never really talked about, and suddenly it was the big thing in contracts once the pandemic hit. So something to keep in mind, but definitely all businesses have come to terms with it, with the virtual ways of working, and negotiations have changed significantly. Now it is not in, of course, in the physical world. You have to keep in mind how things are transitioning, and not just your business, but the outside factors are affecting you more. So you have to give that leeway to the other parties, your suppliers or your vendors as well. So yes, definitely something to keep in mind in the contracts.
Okay, what are the skills required for negotiating a contract?
Skills that are required mostly is, well, presence of mind. And every time you negotiate a contract, I think you have to go with a fresh mind. Believe that you are learning something and giving something at the same time. So never go with a fixed mindset. You may have negotiated 100 contracts, but each one is going to be different. It would never be the same. You have to stay present, focused, in control of the situation. Tempers run very high when stakes are very high. So being calm is very important. These are some things, these are some skills. As you grow in time, and with experience, you definitely become faster. You know what will work, what will not work for the business.
Right.
So that will come with time, definitely. So nothing to worry about over there.
Okay. What are the standard clauses that should be included while negotiating a contract?
So the standard and bare basics are the representations, the deliverables and questions, like I had mentioned, and the indemnity. These are some which we know about, which are heavily negotiated, but never let go of your other clauses which are relevant, like the purpose of the agreement should be stated very clearly. Something which people often miss out on is setting out really what is the purpose of the contract, something to be very, very clear on. Before you start negotiating with the other side, always internally, if you're working with a team, and it's very, very important to take the perspective of every person that's involved. You would be really surprised how many fresh and good ideas you can get. Um, Even if you are working for from as an individual lawyer, it is very important to know what your client really needs and stick to it till the very end. So I would suggest that that is something definitely to keep in mind. In terms of clauses, yes, there are the standard clauses, we all hear about them: confidentiality, privilege, information. But my suggestion would always be that before you stick to a standard clause, look at the interest and pen down what you think is the most important, and then take it forward in negotiation.
Sure. How has COVID-19 affected the due diligence performance of the contracts, negotiating a contract? What is the judicial approach in this regard?
Yes, COVID-19 pandemic has definitely affected the way contracts work. Even the existing contracts had to be interpreted a little more liberally to give benefits to everybody. Uh, Judicially, also speaking, if you've gone through some of the provisions and cases, there have been a lot of benefits that have given because of the disruptions caused in the market. But that being said, overall, the businesses did pick up very fast. One of the things that you notice when you're working for an ongoing business is that you have to step up with the time, and you have to step up to the occasion and to the challenge. So there is no wriggle room around it. Like they say, the show must go on. It had to. All around we are seeing, and unfortunately, people who are involved, whether in business or otherwise, they are going through turmoil at a personal level, at a professional level. And there are people who have to take pace and take those shoes, into those shoes, and step up and move forward. So it is something, not every time we can take the hard end approach of law, because then comes the concept of morality. And COVID-19 is one such time where I have seen people have stepped up to that occasion and worked more collaboratively than against each other. So it is not as disruptive as it seems.
True, true. Why law? What has motivated you to enter this profession?
Okay, so well, I wanted to be a lawyer since school. I think it goes back to long time, and I wanted to always be a commercial lawyer only. It was very fascinating for me when I used to read up about contracts and the commercial elements in economic times. It was something which was always of my interest. But in law school, I did experiment. I went for a lot of internships of different nature, ranging from going to the courts to working with charitable trusts, and working in house, working for law firms. So I got a taste of everything, and I planned my career basis that. It is something I would definitely suggest to all of you, that experiment at least in the first 3 years of your law school, to get what works for you. Always remember, you would be in it for a long time. A career is spanning decades for people, so it should be something you really love doing. So wake up in the morning and feel happy about it, which I still do today, so I'm still a lawyer.
So that's a lesson for our students. I think you said that very beautifully, that you tried your hands onto everything and then you decided which particular specialization you want to step into. How does the command on language affect our ability to negotiate the contract?
Yes, language is really important, because more than anything else, you have to see how your body language is when you negotiate. It's very, very important never to come across hostile or aggressive. It is true that it is very, very difficult to do that in high-stake contracts with so many people and so many things which are involved. But a smart lawyer is one who knows when to keep his cool and to get his job done without, let's say, speaking much. I have had the privilege of working with lawyers who said very less but still got their job done. So that is how you should approach things, that to keep a calm mind through the situation. Remember that you are the person everyone is relying on. So raising an alarm bell every few minutes or red flags every few minutes will cause a panic. So there are people who count on you for it. So that is something to keep in mind. The temperament of a lawyer matters. The command on the language matters. Remember, whatever you pen down in a contract, that really matters. So every word should make sense to you. There are some, as you would go along the way, you would see words which we use, like subject to this, it is clarified this. Each word has its own meaning. It's very, very important not to use them loosely or freely in your contract. So overall, what goes down in paper and what's signed, it really matters. So that is something to keep in mind even when you negotiate.
Okay, great. Increasingly, we have seen that there is a high emphasis on including alternative dispute resolution clauses, especially arbitration in contract. Can you tell in which kinds of contract alternative dispute clauses should be avoided?
Yes, so alternate dispute resolution is a mechanism that is still up and coming in India. In certain cases, we are seeing that it is still disputed. For example, if you are seeing the very high stake matter of Amazon and future retail, that is still going on in the media, where some of the dispute resolution or enforcement of it is being challenged right now. So the provisions, while they are clear, the enforceability, especially from a foreign angle, is still challenged in the court, and it overall makes the whole process very long drawn. So when your stakes are smaller or you're working with, I would say, vendors on a day-to-day basis, litigation is still the preferred route for dispute resolutions versus going through the whole ADR mechanism. One thing to look at from a business perspective is mediation clauses. They are very helpful, and pretty much that is how businesses work. They like amicable settlements. From honestly, from a commercial perspective, nobody wants to go to the court. My suggestion to take up the ADR clauses would probably be extremely high stake matters, where maybe parties have a preference for an outside forum. They're looking for a neutral ground of jurisdiction. So those are some places where it can be used. As the law evolves, it will come into play and ADR will be the way to go. But as of now, you have to strike a fine balance between what clause you're choosing and what is the nature of your agreement.
Okay, great. Ma'am, how can our students enhance their skills in drafting a contract, as we are increasingly seeking or seeing people resorting or relying on the use of set formats and templates?
Yes, I have seen a lot of websites that are promoting use of templates, and well, non-lawyers do prefer it till the time they don't go into dispute and they realize that it is something which is completely contradictory of what work product they were trying to do. So to students, I would first suggest that whatever you study in law school, that is important. The contract law and even other laws, they all tie in together. So don't take it for granted. practice is what will make you draft a good contract, or anything for that matter, whether you are going the litigation route and you want to draft a petition, or whether you are looking at commercial laws and wanting to draft a contract. Practice comes with time, but the most important thing at your age is asking questions. Always ask, don't hesitate, no matter how silly it looks, or you think that this is really irrelevant, or you think that you should know it. Honestly, nobody knows it. We are still all learning. I'm still to come across a lawyer who's, and very senior lawyers who can say that we know everything. They in fact tell me, we are still learning. We are learning from your generation. So uh, keep that inquisitive mind and ask. Always ask. If you are in doubt, why did this clause go here? Why didn't I see it in the previous contract? Make sure you ask this question, and that's how you will learn.
Right. Ma'am, what is your take on framework for the negotiation of electronic contracts and e-business on demand?
Electronic contracts is something which is still coming up in India. So if you look at the Information Technology Act, it sets out some rules for electronic signatures or digital signatures. And then we have the concept of e-stamping. All these are important because a contract has to be stamped and signed. During the COVID-19 situation, we did saw big disruption because we could not freely stamp or sign the contracts. And overall, the e-contracting phase was not fully recognized in India. So that was a transition to be made. If you look at it now, more and more governments, especially in case of stamping, state governments are stepping up and allowing this process to happen. It will take some time because I think as a country, we are still evolving to fully adapt to the digital space. It is, of course, recognized in other jurisdictions and well recognized in foreign jurisdictions, including this concept. But for India, while it is taking some time, I think it would be the way to go. As of now, the preference is still more of the physical mode, fully stamped and executed contracts, because it was what we had been following. Some things to keep in mind, of course, that if you're doing a digital contract, as time passes, more security related provisions would kick in, more encryption based contracts would kick in, so that there is a method to ensure that these have not been tampered with. Probably things like a wastage of paper maybe is one way to see, which would stop, which is something we do. Lawyers love taking a lot of printouts of things. But this will take some time in my experience. Yes.
Right. What is your take on the notion of work-life balance and what keeps you busy other than work?
Work-life balance is very important. But yes, to begin with, in my initial years of career, and I'm sure all lawyers would say the same, there was a lot of hard work and not much of so-called work-life balance, so to say. You have to find time for yourself. um, you cannot blame your work for it. It is how well you balance that creates a work-life balance for you. So that's something to keep in mind. I think, I mean, I still struggle with it, and so does everyone I know of, but that just depends on what are you defining it as. You think having a 9 to 5 is something that will cause a work-life balance? It's not necessary. It depends on what your priorities are. And in terms of what keeps me busy other than law, well, I'm an avid weightlifter, so I like to lift. And I also am a wellness freak, so I do meditate quite a bit. So those are things that I have been practicing since 7-8 years. And both of them actually also help me with my profession, because meditation helps keep a lot of focus. And I have noticed that during difficult negotiations, I am able to keep quite still and calm. No, I would not promote it to anyone, but find something which is of your interest other than law, something which you like and makes you happy, and it will automatically reflect in whatever you do as well.
True, very true. So personally profounding and enriching experiences helps us keep a professional balance as well.
Yes.
True. Lastly, since we have very limited time with you, one last question that what is one piece of advice that you would like to share with our budding lawyers or would-be lawyers at our law school?
Um, well, enjoy your law school. I would say I took it really seriously. That being said, whatever you do in law school matters. It goes a long way. Marks show your consistency. I know that now we have a lot of people saying marks don't matter, but they are a way of showing that you are consistent, you are present, and you know that you're good at something. So yes, they do add overall. In case that is not something to your interest, take up something in law school, which is whether you're into moot courts, and excel in it. So consistency is a mark of a good lawyer, no matter what that consistency, wherever you're presenting it in your life. So make sure that that is something you keep at. And yes, enjoy your law school years, they don't come back. That's what I would say.
Great. Thank you so much, ma'am. It was indeed a very interesting session with you and how you've handled all the questions and you shared such relevant information with our students. And we look forward to a continued association with you as a mark of acknowledgement. And we're truly humble towards you coming here and for your presence. We would like to acknowledge your presence with a memento.
Thank
That's for you. And as I said, we look forward to a continued association with you. Our students would be very happy to take your guidance even in future. So AEG and ALC looks forward to an association with you in future as well. Thank you so much, ma'am.
Thank you for having me. Thank you, students.